Thank you for waiting. Before the team from the United Patent Court in Europe hold its mock trial, and I will introduce the members of the panel. Playing the role of the judges from the Court of Appeal of the Unified Patent Court, President of the Court of Appeal, Klaus Grabinski. Playing the attorney for the plaintiff is, from the Kata Augenstein law firm, Attorney at Law Christopher Augenstein. Playing the attorney for the defendant is, from the De Brau Blackstone Westbrook law firm, Attorney at Law Anne-Marie Belchou. And on the tablet handed out at the venue, please look at material number 5, the UPC's mock trial slide. Please go ahead.
Good afternoon. This is the case Pony and Danke. It's an action for infringement, but also counterclaim for revocation. So, Mr. Augenstein, to my understanding, you represent Pony, the claimant in the infringement case, correct?
Yeah, that's correct.
And you represent Danke?
Correct.
Correct? Mr. Augenstein, you referred to your requests in the written submissions regarding the action for infringement, so you require a cease and desist order, an order to give information, and also a decision on the liability with regard to damages.
That's correct, yes.
And you asked the court to dismiss these requests.
Yes.
And you also asked the court to revoke the patent.
Correct.
And you asked the court to dismiss the request to revoke the patent.
That's correct, yes.
Very good. Then, as to the context, two questions were raised in the case. The one question is about the interpretation of the patent claim, particularly what is to be understood in the context of the patent claim to be a through hole. And depending on the interpretation, the court will have to consider infringement or not. And secondly, the question of whether the patent involves inventive step has come up, and with regard to a particular piece of prior art, a US application. And I'd like you both to focus on these two issues. And I like you, Mr. Augenstein, to argue first the action for infringement.
Yeah, thank you very much, Your Honor, for this introduction. I think I can be very brief in this matter because the facts are undisputed. The design of this storage container is very, very clear. So, and there is only one counter argument the defendant puts forward, and that is that the through hole would be too small. And there again, I think the first issue is apparent. Too small compared to what? Because the decisive thing here is that the claim doesn't say anything about the size. So we have only in the description a particular embodiment where the size of the hole is mentioned at all. But we all know that a particular embodiment must not limit the scope of the claim. So therefore, there is no basis for this argument because the claim is absolutely silent with respect to the size of the hole. So the only possible argument could be that the hole does not perform the function that is attributed to it. But again, there it is undisputed that water can flow out of this through hole so that the user can get rid of excessive water within the container. So on the basis of all the undisputed facts, the infringement is very clear.
Thank you, Mr. Augenstein. And now I hand it over to you, Mrs. Verschoor. And on the one hand, you may defend your client with regard to the arguments of infringement, But on the other hand, you may continue with also bringing your arguments in favor of your request to revoke the patent.
Thank you very much. Your Honor, today I will first briefly introduce the matter, then I will explain that and why there is no infringement. I will indeed explain the revocation claim, and then just a few brief concluding remarks. So what is this case really about? It's about a patent that claims a particular lid, a lid on top of a container that has a hole that can be closed with a flap. That's nothing special. This kind of containers already existed. Should go back. And then, even if the patent would be held valid, there is still no infringement because there's just a tiny hole in the defendant's product, and it's far too small to allow for a smooth discharge of water, as the patent requires. So let's look a bit closer at no infringement. Claim 1 of the patent does indeed require a through hole. That is true. That through hole, however, is used for discharging excessive water, as you can also see in figure 4 of the patent over here. It is, however, necessary to look a bit closer at claim construction here, because it's not as simple as my esteemed opponent says. The UPC Court of Appeal has ruled in its case law that the interpretation of a patent claim, in fact, does not solely depend on the literal, strict meaning of the words used. The description and the drawings must, and I should stress must, always be used as explanatory aids for the interpretation of the patent claim, and thus not only to resolve any ambiguities. If we then apply this to the patent, it's clear that only through holes that prevent water splattering and thus have sufficient size, so not this tiny hole, no, they need to have sufficient size, are covered by the patent. And for that, I would like to refer to the description and the drawings. And I will not discuss any reference in the description here, because in fact, in my initial written submission in this case, I've of course already set this out in detail, but I would like to highlight a few items from the description. For example, at the second bullet here. I'll start with the first, just for clarity. The lid can prevent water from hitting the flap while discharged from the through hole, and that allegedly solves the problem that the water drained from the through hole hits the flap and splatters. How then does this happen? And then we go a bit further. This through hole is designed to in fact have such a size, so it needs to have sufficient size, that the water inside the storage container can be smoothly discharged. And then it becomes even more specific. It says the diameter should preferably be between 10 to 20 millimeter. If we then look at the defendant's product, the through hole is far too small, not just a little, far too small. And that's not strange, because it's actually meant to release excessive pressure, not for smoothly discharging water. And thus the size of the through hole in the defendant's product is just 3 millimeters. And that's so far away from the 10 to 20 millimeter as disclosed in the patent. And therefore, actually, the hole in the defendant's product does not effectively discharge water. And this is not just me telling you this. There's proof, there's evidence in the file. A third-party experiment confirms that there has been no smooth discharge. It takes over 60 seconds to just drain a very little amount of 100 cc of water. Therefore, my client concludes that there is no through hole as required by Claim 1 of the patent. And then let's look at the counterclaim for revocation that has indeed been filed, and for good reason, because there is no inventive step. In order to establish that, of course, we first need to look at the skilled person. Who is the skilled person here? That is an engineer with several years of experience in developing and designing storage containers using heat-resistant plastic materials. And this skilled person has a commercial interest and motivation to find practical alternatives. So that's the skilled person. What is then the closest prior art here? That is a US patent with a number indicated here on the presentation, and that teaches a lid as part of a storage container on which a through hole is located on the outer periphery of the top plate portion. And that's a storage container that's suitable for heating in a microwave oven. This prior art document thus relates to the same technical field as the alleged invention and is therefore a realistic starting point for establishing inventive step, or I should rather say here, the lack of inventive step. There are two small differentiating features between the patent, alleged at least, and the prior art document. First, it is stated that the patent discloses a container to heat food in a microwave oven, whilst the prior art document would only concern defrosting. And secondly, the patent has a protrusion that can close the through hole, which is spaced from the through hole in its natural position. So let's first look at this first point, the heating. Well, actually, the prior art document expressly mentions that it concerns heating in a microwave oven. And I refer, Your Honor, to paragraph 12 of the description. Also, it mentions that a container needs to be heat resistant. It needs to resist up to 100 degrees Celsius, which is clearly a lot. So heating is maybe not so much of a difference. Then the flap. Both the patent and the prior art document, in fact, have a flap located on the top portion of the container. And this is actually claimed to be a key to the invention, as it helps solve the splattering problem. Before, the flap was located on the lower part of the container. There is, admittedly, a small difference with the prior art document. The natural position of the flap, which has a protrusion that can close the through hole and which is manually adjustable in the patent. Such would, however, have been a mere obvious design matter for the skilled person, which he would have had an incentive to arrive at. Why would he have had that incentive? Well, when one wishes to remove excess water, it's of course advantageous to have a flap that can be manually adjusted, either in the open or in the closed position. If the lid would always automatically return to that closed position, it would be difficult to smoothly discharge the excess water, because then it would, hit that flap. So therefore, the skilled person would wish to have the possibility to manually open the flap. Then it's common general knowledge that a flap that can be manually opened and closed is designed by applying a protrusion to the flap that can close the through hole. So applying this knowledge then, the skilled person would very easily arrive at the invention as claimed in the patent. And then maybe just one last substantive point. To the extent that Pony argues that such design change would interfere with the suction system of the prior art document, and in short, prevent automatic closure when suction ends, first of all, there's a formal point here. This has not really been substantiated, and Donkey disputes it. And then secondly, perhaps more importantly, there's two different things here. Of course, the manual operation enables closing the flap, so the flap can be closed when heating. Equally though, for example, afterwards, the flap can be opened for discharging the excess water. And in fact, it's quite illustrative that both the patent and the prior art document also show a closed flap, as is indicated here on the screen. I come to my conclusion. To conclude, Donkey requests the court to first of all dismiss Pony's claims, to, in the counterclaim, revoke the patent, and lastly, to award Donkey's legal costs. Thank you.
Thank you very much, Mrs. Verschoor. And now I hand it over to defendant in the counterclaim for revocation to bring forward your arguments. Mr. Augenstein.
Thank you, Your Honor. Well, we heard a lot about the invalidity arguments of the defendant's side. And one little detail is that my esteemed colleague used the word heating for the prior art document, where the more precise word of what is described would be defrosting. So I just wanted to highlight this overlooked difference by my esteemed colleague. But what I think is even more important is that it is undisputed again that there is no protrusion provided with the prior art citation. So all we can discuss is inventive step here. And then we must ask ourselves, what would be the motivation of the skilled person to change from this, I would call it, automatic system to a manually operated system with a protrusion where I can say, well, I can reliably close the container, which can be a desired function, for instance, if you want to transport food in such a container, which I think is pretty obvious that one could desire to have such a function. And when we look at the prior art citation, this function cannot be provided because we have this automatic system where differences in pressure automatically result in an opening of the container. So that there is no motivation for the skilled person to change that mechanism that works well for heating, to get rid of excess pressure. It even works well when you would like to apply a vacuum. That from this perfectly workable system, solving a lot of different problems, to all of a sudden have a system with a protrusion where a different purpose and different object will be achieved. And when we look at the situation of applying the vacuum, it's also pretty clear that with a protrusion you would never achieve to the vacuum, because everyone knows that if you apply a vacuum you would have to stick the flap with the protrusion. Again, the air would immediately come back to the container and the effect would be gone. So that's why I strongly believe that a skilled person would never replace this automatic system with a protrusion. And I think we made it pretty clear in our submission why the skilled person come to that end, and we feel that the defendant did not really counter-argue against that, so that this argument is unsubstantiated.
Thank you very much, Mr. Augenstein. Do you want to have a last word, or?
I'll be very brief, thank you. I believe regarding the first point, I have explained, in fact, why heating is mentioned in the prior art. Indeed, the second point, that the protrusion is not there, that's not so much disputed. But there is, of course, a clear motivation to change the system, if you will, because always water does accumulate when something is heated, so a skilled person will be motivated to change that. Thank you.
Thank you very much. I think we exhaustively have discussed the case. And now at the UPC, it would not be just me, but 3 more judges, including a technically qualified judge. We would go to a deliberation room, deliberate the case, and normally the decision would be published later, but today we make an exception, and we make it very quick. And now the judgment in the case. So the case raises 2 issues. The one concerning interpretation of the patent claim with regard to the through hole. And it is essentially about element F of the patent claim 1, which requires that the through hole of the top plate is formed outside a base and portion of the flap in plan view of the lid. The technical purpose of this design is to allow water to drain through the through hole without hitting the flap and splattering. Patent claim 1 must therefore be interpreted to allow water to be removed through the through hole. There are no requirements as to the size of the through hole as long as it allows water to be removed from the storage container. We've seen a citation from Mrs. Verschoor from the description, and it is about a diameter preferably 10 to 20 millimeters. So there is no requirement, it's only preferable. As long as water can be removed through the hole, even if it's only 3 millimeters of diameter, it is enough. And even if it takes 60 seconds or even more. What about the splattering? Well, the court takes the view that the splattering shall not be achieved by the size of the hole, but by the positioning of the hole. So by positioning the hole of the top plate, so it's formed outside the base and portion of the flap. And as it has nothing to do with the size of the hole, it cannot be an argument in favor of the position of defendant. And in light of this claim interpretation, it easily follows that the patent has been infringed, literally infringed by the attacked embodiment. And that gets me to the second issue that has to be dealt with. This is to deal with the counterclaim for revocation and with the issue of inventive step. And in that regard, I would like to cite the relevant provision of the European Patent Convention, which is Article 56. An invention shall be considered as involving an inventive step if, having regard to the state of the art, it is not obvious to a person skilled in the art. And the court considers a person skilled in the art to be an engineer with several years of experience in developing and designing storage containers using heat-resistant plastic materials. And the first thing that then has to be dealt with is the underlying problem, to define the underlying problem. And in that regard, the starting point for the person skilled in the art would be a storage container with a lid as known in the prior art and shown typically in figures 5 to 8 of the patent specification. In such a container, food can be heated in a microwave. And the container comprises a lid with a flap that has a protrusion that can close a through hole in the lid by which excess water can be removed. And the flap is arranged below the through hole at an outer periphery of the lid. And that configuration results in the problem that the water drained from the through hole, when it is not closed by the flap, hits the flap and splatters. Now, for a person skilled in the art who is trying to resolve this problem, the prior art, US Patent Application 77 of 2006, is of interest. Why? Because it concerns a storage container with a lid, like the other prior art, where the problem results from. It also is made of plastic with a heat-resistant temperature range of -40 to 100 degrees Celsius. And it also has food, is storing food in the container that can be defrosted in a microwave oven. So also microwave oven like in the prior art where the problem is. And the lid is provided with a flap and a through hole outside the base end portion of the flap. So it's worth for a person skilled in the art to have a look at this prior art. However, the flap does not have a protrusion that allows to close or open the through hole, depending on whether excessive water is to be removed from the container. The function of the flap, so without the protrusion, disclosed in the US patent application is rather that of a non-return valve after vacuuming the container through the through hole by a vacuum pump. So it is a completely different function. As the flap is pressed to an annular area around the through hole when the pressure inside is lower than the pressure outside the storage container. So it's not supposed to open and close depending on whether water shall be removed from the container, but it shall, once it has been closed, it shall always be closed with regard to the vacuum of the container. And in view of this different functional context, the person skilled in the art had no reason to consider the position of the flap as disclosed in the US patent application to solve his problem of preventing excess water draining from the open through hole from hitting the flap and splatting. It follows that it was not obvious for the person skilled in the art who was supposed to solve the problem underlying the invention to come up with a solution including element F of claim 1 of the patent in suit. So the decision of the court is that the court, as no other arguments have been brought forward, is that the court will order cease and desist, will order obligation to give information, and will also decide in principle that defendant is liable to pay damages. And at the same time, the court will dismiss the counterclaim for revocation. That concludes the case.
With that note, we close the mock trial by the team from the UPC. Thank you to all the panelists.